DeWaal here, and this is Bridging the Weeks for August 31st to September 11th, and today is September 14th, 2015. Good morning. During the past 2 weeks, Navinda Singh Sarao, the individual both the U.S. Department of Justice and the Commodity Futures Trading Commission claim was at least partly responsible for the May 6, 2010 flash crash, was formally indicted for alleged spoofing type trading, while the National Futures Association issued its proposed guidance to members regarding cybersecurity. Meanwhile, the U.S. Department of Justice also suggested it will proceed more fervently against employees of alleged corporate wrongdoers going forward. I am just back from a week of vacation and hiking through the wilderness of Bryce Canyon and around Los Angeles, so we have a lot to catch up. Let's get started. The U.S. Department of Justice filed a formal indictment against Navinda Singh Sarao in a U.S. federal court in Chicago on September 2, 2015, alleging that he engaged in commodities fraud, manipulation, attempted manipulation, and spoofing in violation of federal law in connection with his trading of e-mining S&P 500 futures contracts on the Chicago Mercantile Exchange between approximately January 2009 through April 2014. Previously, Mr. Sarao was accused of engaging in the same unlawful activities in a criminal complaint filed in the same court by the Department of Justice on February 11, 2015, and made public on April 21st, and in a civil lawsuit filed by the Commodity Futures Trading Commission in a U.S. federal court in Chicago on April 17, 2015, but made public on April 21, 2015. The Department of Justice and the CFTC claim that Mr. Sarao engaged in layering activity on multiple occasions on the sell side of the market with the intent to mislead other market participants and artificially lower the price of e-mini futures contracts. Mr. Sarao typically sold e-mini futures contracts at a higher price and bought them back at a lower price in conjunction with a supposed quote-unquote dynamic layering technique, realizing profits claimed both the Department of Justice and the CFTC. In the indictment, the Department of Justice provided greater insight into its version of Mr. Sarao's alleged wrongful conduct. Among other things, the Department of Justice referenced specific emails when Mr. Sarao expressly referenced his desire to quote-unquote spoof the market down, his need to have software to enter orders of different sizes to avoid other traders becoming aware of activity and, quote, rendering my spoofing pointless, end of quote, and contacting a programmer to know whether he can make programming adjustments, quote, because at the moment I'm getting hit on my spoofs all the time, end of quote. Both the CFTC and the Department of Justice claim that Mr. Sarao's conduct contributed to the May 6, 2010 flash crash. The U.S. Department of Justice issued an internal memorandum requiring department staff to proactively seek quote-unquote accountability from individuals who cause corporate misconduct. According to the memorandum, quote, such accountability is important for several reasons. It deters future illegal activity, it incentivizes changes in corporate behavior, it ensures that the proper parties are held responsible for their actions, and it promotes the public's confidence in our justice system, end of quote. Among other things, the memorandum says that going forward, to qualify for any cooperation credit, a corporation must completely disclose to the Department of Justice all, quote, relevant facts, end of quote, about individual misconduct. Department of Justice investigations must also, quote, focus on individuals from the inception, end of quote, of any investigation, and no corporate resolution may preclude criminal or civil sanctions for any individual absent extraordinary circumstances. Moreover, says the memorandum, no corporate cases should be resolved without a quote-unquote clear plan to address related individual cases prior to any statute of limitation expiration. The National Futures Association submitted to the Commodity Futures Trading Commission for its approval a proposed interpretive notice requiring certain NFA members to maintain formal written information systems security programs. Impacted members are Futures Commission merchants, commodity trading advisors, commodity pool operators, introducing brokers, retail foreign exchange dealers, swap dealers, and major swap participants. Although the NFA makes clear that its, quote, policy is not to establish specific technology requirements, end of quote, it will require all relevant members to have supervisory procedures that are, quote, reasonably designed to diligently supervise the risk of unauthorized access to or attack of their information technology systems and to respond appropriately should unauthorized access or attack occur, end of quote. NFA expects, however, that firm supervisory systems will likely be different from one another, quote, given the differences in the type, size, and complexity of members' businesses, end quote. Commodity Futures Trading Commission Chairman Timothy Massad provided insight regarding a number of current Commission initiatives before the Beer Institute's annual meeting last week. Among other matters, Mr. Massad indicated the CFTC will finalize rules regarding margin for uncleared swaps, suggesting that it will include a proposed exemption for commercial end users. Without committing to a date of release of final rules relating to position limits, Mr. Massad suggested that, quote, we will have more to say about issues related to position limits in the coming months, end quote. Mr. Massad acknowledged that, quote, hedging strategies are varied and complicated, end quote, and suggested that the Commission has taken a closer look at having exchanges not the CFTC review applications for so-called non-enumerated hedging exemptions. Mr. Massad also indicated the Commission is likely to issue proposals during the fall, quote, to minimize the chance that algorithmic trading can cause disruptions or result in unfairness, end quote. The Securities and Exchange Commission filed and settled charges against BDO USA, a national audit firm, and 5 of its partners for issuing misleading, unqualified audit opinions on the financial statements of General Employment Enterprises, an employment staffing services company, for the firm's fiscal years ending September 30th, 2009 and 2010. According to the SEC, near the end of BDO's 2009 audit of GEE, GEE's chief financial officer advised BDO that a U.S. $2.3 million certificate of deposit the firm had purchased had not been repaid timely by the issuing New York State chartered bank. At the time, the amount of the CD represented approximately 1/2 of GEE's assets and most of its cash. In following up on this matter, BDO received conflicting stories from GEE management and board members regarding the CD, although the firm ultimately received a series of payments equaling the amount of the CD from 3 entities unaffiliated with the bank. Later, BDO dropped this demand without adequate follow-up, said the SEC, and issued unqualified opinions that were included in GEE's SEC filing of required financial statements for 2009 and 2010. To resolve the SEC's charges, BDO agreed to pay a $1.5 million US dollar penalty, to disgorge profits and pay interest totaling approximately $600,000 US dollars, and to commit to various undertakings. The 5 partners agreed to pay in aggregate a fine of $75,000 US dollars, and 4 of the partners were prohibited from appearing before the SEC as an accountant for at least 1 to 3 years. The SEC also brought separate actions against GEE's former board chairman, Stephen Pence, who is a former U.S. attorney and lieutenant governor from Kentucky, as well as against 2 former GEE chief executive officers. And finally, the UK Financial Conduct Authority expressed concern that, in connection with a thematic review of 12 commodities brokers and trading firms, some firms evidence quote-unquote complacency towards the risk of market abuse and weakness in intraday risk monitoring. Many firms also could not demonstrate quote-unquote effective procedures to identify and report suspicious transactions. According to FCA, quote, we are concerned that some firms believe commodity markets are too deep, too liquid, and there are too many participants to be manipulated, end of quote. The FCC said this conclusion is misguided and surprising in light of recent cases of manipulation in other deep and liquid markets, for example, in LIBOR, foreign exchange, and gold. Besides finding few firms with adequate intraday risk monitoring, FCA also concluded that, quote, credit risk was usually assessed but left unhedged, end of quote, while, quote, market risk was usually given consideration, but on a portfolio basis, little attention was paid to concentration risk, which in the event of stressed market conditions could result in large financial pressures and liquidity risk, end of quote. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week, and as always, ciao!